So happy to introduce and really looking forward to this discussion. The first, let's just say 115 days of Trump 2.0, new SEC leadership, priorities, and organization, ... What comes next? I'm interested, as we all are. So our moderator is Jordan Eath, partner and co-chair of MoFo's Global Securities Litigation Enforcement and White Collar Defense Group. Jordan's also a fixture at this conference, having for many years moderated the directors panel. To Jordan's left is our SEC panelists, Kate Zoladz, the Deputy Director, Enforcement West at the SEC. And then we're rounding things out with Michele Layne of Counsel at O'Melveny, former Regional Director of the LA Regional Office, a role that culminated a very distinguished run at the SEC. To Michele's left, Justin Sutherland, the Director at AlixPartners.
A pretty decent accountant.
Pretty decent accountant. He told me last night that he was going to have nothing to offer.
That's what I came up with. I thought about it.
He's at the baseline, and he can only get better from here. Very experienced accountant, having worked in a variety of roles at the SEC. And then finally, Alex Wyman, a partner at Latham. And prior to joining Latham, Alex was an AUSA in CDCal here in Los Angeles, where he was the corporate fraud coordinator and securities investment fraud coordinator in the major frauds section. Jordan?
Thank you very much, Peter, and good afternoon, everyone. Directors panel, RIP, no more. Well, looking back over the years at those directors panels and the things that we discussed, it seems a little quaint in this moment, don't you think? I mean, shadow trading and admit or deny, ESG, all that, it's kind of fun when you look back. Those are the things we really talked about, niceties, subtleties, that kind of thing. Now, some people think that the SEC is facing the biggest changes ever. That's what some people think. We are 115 days in, not 2 years in, but that's what some people think. And if you look at numbers in the first 100 days or so, far fewer actions have been brought than even Trump won, or even during Biden, a third or a quarter, depending on how you count. But it's not about the numbers. It's about the substance and about all the changes. For example, crypto, which I think we've talked about a few times today. I think it's come up in some conversation. So FCPA, there usually have been panels on FCPA, and it's barely come up here. What about internal controls and off-channel communications, all those kinds of things? And the actions that we have seen have all involved real fraud, not non-fraud fraud. And I still want someone to explain that to me, whatever that means. But we haven't seen those kinds of cases. And then you look at the comments made about the prior SEC. And these are just quotes, a stark aberration. Investor protection cannot be achieved through paternalistic policies. Long-held reputation the SEC has suffered. And we even heard at lunch today that the prior SEC, at least with respect to crypto, was irresponsible. Turning to priorities, we are told no more regulation by enforcement. It's going to be more business friendly. Craig Martin notwithstanding, that's what they said. More business friendly. That creativity is not where we want to be. Here we are in Los Angeles, we're told no creativity, right? So what we're going to do is we're going to turn to some of these subjects. And even though we've covered many of these subjects in panels today, we have Kate. Remember that. We have Kate. And Kate, congratulations on your promotion.
Thank you.
And you are the head of what territory now?
The West, Deputy Director of the West. I feel like I need a little badge or like a cowboy hat or something like that.
This is the Good Witch of the West?
It is the Good Witch of the West, yes. So the offices that are under my area are Los Angeles, San Francisco, Fort Worth, and the Denver office.
Okay, very good. So we're going to talk a little bit about the priorities, and what I've heard and read is that it's going to be more bread and butter. Bread and butter. So does that mean like Ponzi schemes and penny stocks, or what is that? What does bread and butter mean?
Okay, well, so first of all, with that intro before, I think I'm definitely going to have to give my disclaimer.
Okay.
So my comments today are provided in my official capacity as a Deputy Director in the Enforcement Division of the Securities and Exchange Commission, but do not necessarily reflect the views of the Commission, Commissioners, or the staff. So, reaction to all of that, bread and butter, I think I'm just going to paraphrase Mark Twain to start. I know we had F. Scott Fitzgerald earlier. I'm going to go with Twain. The reports of the SEC's death have been greatly exaggerated. So, the work of this enforcement staff continues. We're still going to investigate matters. We're still going to hold bad actors accountable. And it's been said many times today, but Chairman Atkins has only been in the job for about 3-4 weeks. So to be clear, I'm not in a position to announce any new priorities today. But I think you can expect to see a return to basics and an approach that's tied to our mission. And that's to protect investors and to ensure the fairness and integrity of our markets while fostering capital formation.
Kate, that's what every SEC says. They don't change those words. There's no SEC that said we're not here to protect investors, right? So what does it mean back to basics?
Back to basics. So I think you can look at what we've done the last few months, and I think that's going to be instructive for what you're going to see going forward. So we've brought cases in areas like insider trading, false statements in connection with raising capital, breaches of fiduciary duty by investment advisors. So I thought I would just highlight a few of the cases that we've brought over the last few months, because I think you're going to see more of this type of stuff. So the One Oak Capital Management was kind of alluded to earlier. We announced settled charges in February with an investment advisor and its registered rep for failing to disclose a conflict of interest. The registered rep, Michael DeRosa, converted brokerage accounts of certain clients to an advisory relationship with his new firm without telling his clients that they would face significantly increased fees. In March, in Los Angeles, we charged George Demos, a former VP at Acadia Pharmaceuticals, for insider trading in advance of an announcement of negative news from the FDA to avoid losses of about $1.3 million. He also pleaded guilty in parallel charges brought by the U.S. Attorney's Office for the Southern District of California. In April, the SEC filed a complaint against the founder and former CEO of a privately held technology startup, Nate Inc., for fraudulently soliciting investments and raising over $42 million based on false claims over its use of AI. The former CEO allegedly told investors that his company's mobile shopping application used AI to process transactions, when in reality, the company largely relied on contract employees to manually input orders placed by users on the app. And Ponzi schemes. So, even more recently, we brought charges against 3 individuals in Texas for operating a $91 million Ponzi scheme through Vanguard Holdings.
So, Michele, what are you seeing in terms of priorities?
So, we're seeing a fair number of insider trading cases, some accounting, potential revenue recognition cases. So, I get the bread and butter aspect, right? And I also get return to basics, and obviously the Commission's mission hasn't changed. It's the same. So I do think my big takeaway is actually what Sam Walden said at SIFMA when he said, quote, "I don't think creativity is where we want to be right now." So if you look back over time, despite administrations largely, and as proactive as the SEC tries to be, on the enforcement side, it is reactive. And what does it react to? What's in the market. So, I would envision the changes are going to be some of the charges that are ultimately made and some of the cases, the types of claims that will be brought as maybe a standalone claim. So all of the cases that we've heard about today from the SEC that have been filed since January 20th all fall into just pretty much straightforward frauds in different formulations, but at the end of the day, that's what those cases appear to be about.
But what about the creative? What would be a creative case that we're not seeing?
Well, I think some people believe shadow trading, the Panawat case, was creative. Others, have a different view. But perhaps some of the standalone internal controls violation cases where there's no accompanying alleged misstatement, misleading disclosure, I would assume that a standalone case, just bringing that violation, is probably not where this commission is going to be.
All right, let's turn to the topic that almost every group has talked about so far, which is crypto. And we have the new unit, and we've heard about the new unit and C2 and all of that. So is crypto one of those creative areas, or is that a regulation by enforcement area that it's now, unless it's bread and butter fraud, it's safe to be crypto?
So you're right. The current formation of C2, the Cyber and Emerging Technologies Unit, has replaced CACU, the Crypto Asset and Cyber Unit. I would just note that that's not the first name change we've had in this area. What is now C2 was originally formed as the Cyber Unit in 2017, and it became CACU in 2022. So the focus of that unit is on combating cyber-related misconduct and protecting retail investors from misconduct in emerging technologies. That does include crypto. The misconduct I think they're going to be looking at is going to resemble traditional securities fraud schemes like Ponzi schemes, but with a crypto wrapper. But the focus of the unit is broader than crypto. It's meant to be flexible and more broad. They're not just going to focus on crypto, but on AI and cyber-related misconduct. But you're right. I mean, I think C2 is going to be more focused on fraud. But that said, they're also going to focus on registrant compliance with cybersecurity regulations.
Justin, what's your perspective on this?
So 2 points. First of all, Kate, I think, nailed it with the breadth, right? So you have a task force now that I'm less concerned about whether or not there's something they're not doing. I'm more interested with the fact that their breadth has changed, has expanded. They are more likely to be technically sound on more topics. So if I'm working with the staff or helping a company that's being investigated by the staff in these areas, I expect that the staff will be more technically sound in this space. Typically, I think a lot of us have experienced working with a member of some of the task forces that the SEC has. I would say that those task forces typically benefit those investigations quite significantly. You get to the point much quicker. Your meetings with the staff are much more technically sound and focused. And so when I look at the creation or the expansion, I would say, of the scope of this task force, that's what I see is now, if I have a matter in touching on any of those topics now covered with that staff, I want to make sure that if I'm giving representation to a company, our team is equally technically sound on those topics so that we can have as a very productive and effective dialogue with the staff and make good use of that. That's what I see.
So is that going to favor your clients?
You know, that's a really good question. I would say yes. Okay. I mean, I don't know if you've ever, when you go into a meeting with the staff and there's someone there that's very technically sound on the topic that's being investigated, it is a world of difference, right? So when I was on staff, and the staff are always asked to get smart on things that they've potentially never really dealt with before. And there's a learning curve, just like anything else, and we deal with it when we represent our clients as well. You move through that learning curve so much faster when the right technical expertise are there. That's what I expect, and that does benefit our clients. The investigations are shorter. There's the subpoenas are more focused, and you spend less energy, consume fewer calories pursuing things that don't need to be pursued.
All right, let's turn now to cyber, which we've also heard something about. Now, for years, defense lawyers have said, look, we're the victim. We're the victim. Don't go after us. You're just penalizing us again. And it sounds, Kate, like that might be the approach now that the SEC is going to take, at least be more sympathetic to that point of view. That, we were just hacked and we just had this horrible thing happen, and now you want us to pay a penalty for that? Is that true? Is there a shift in that way of looking at it?
So I think more generally speaking than cyber necessarily, I talked about what we are prioritizing, and I think I can now talk about what we're less focused on. So I think we're going to be less focused on violations that don't involve fraud, especially where they've been fully remediated. I don't want to overstate this. I think we're still going to be looking at non-fraudulent conduct where it's severe, long-term, or ongoing. And I would just note that I know we're talking about a lot of big changes, but I don't know that this is necessarily a novel approach. It's consistent with Section 2 of the Enforcement Manual, which lays out what the staff should consider when determining whether to open an investigation. And the very first question you're supposed to ask, do the facts suggest a possible violation of the federal securities laws involving fraud or other serious misconduct? So I think, when I say
Section 2 of the...
Section 2 of the Enforcement Manual.
Section 2.
I encourage everyone to look it up. So, I think we're going to continue to reward self-reporting, cooperation, and remediation. And, I think we can decide in appropriate cases that we may not bring an enforcement action at all where all of that's happened. Similarly, I think where registrants remediate or cure exam deficiencies, you're going to be less likely today to see an enforcement referral than you may have in the past.
Mm-hmm. Alex, what's your view on that?
Well, it's funny, the last time that Kate and I sat on a panel like this was mid-2023, which was a very different posture with regard to this type of case. And that fell right on the heels of the SEC's amended complaint in the SolarWinds case, which I'm sure we all remember from the significant cyber attack on SolarWinds from 2020. That case, as we all remember, was criticized in large part because, as you said, Jordan, you have a company and the other companies that were charged by the SEC as part of that fallout, where they are the victim. And now they're being charged by the SEC in addition to that. So you get kind of a double whammy for those companies. I expected the response that Kate just provided from what we've seen publicly, that the SEC's priorities have shifted away from those types of cases. But I think reading Chairman Atkins's public statements, it goes a little bit more broadly than that. From what we've seen, Chairman Atkins has a real recognition of the cost that enforcement actions can impose on companies and their shareholders, both from the investigation itself and from any penalties that are imposed, which are often passed on to the corporation's shareholders. And so I think what we'll see is fewer enforcement actions against companies who are victims from the activity itself, as a sort of recognition of the harm that it can cause toward a company's shareholders who are otherwise innocent in the conduct involved.
Will that lead to more self-disclosure? Because if the SEC's view is, well, the victims, and if you've remediated, so maybe now you'll come forward if it's easier to get that credit. Is that something you foresee, or will it cut the other way? Like they don't really care about it, so why bother?
Well, I think time will tell. I expect the commission will certainly incentivize that kind of self-disclosure so that both sides are getting what they want, but I think it remains to be seen.
All right, let's talk just a little bit about FCPA, and I'm not going to ask you about that, Kay. I'm not going to ask you. I'm just not.
I appreciate that.
I'm just not. But you can chime in if you like. So the president said that the world is laughing at us, and that if we minimize FCPA, or maybe eliminate it, I don't quite remember how he put it, it's going to mean a lot more business for America. And I guess my question is FCPA enforcement really paused, or is it not paused? Because I've heard conflicting things, that some of the enforcement's still going on. And we heard about a loophole earlier today, that if it's against, well, I wrote it down, a corrupt official. I don't know. I thought that's what this whole thing was about, FCPA. I mean, I don't know. Like, and China and what China's all about, and so I'm confused. So Michele, we'll start with you. What's really going on with FCPA, and is it on its way out? Is it on its way back? Is it just resting? What's happening?
Well, I'd like to say I'm not confused, but I'm a little bit confused, but not terribly. So as far as the SEC's posture on FCPA enforcement, I think it's just going to be TBD. So we heard about the loophole this morning. There's some indication, at least in DOJ's statement, that if it involves cartels or certain other types of misconduct, that might be the type of FCPA case after this pause that would be pursued. But that being said, any public company, many of which do business internationally, it's not just the FCPA and DOJ. They have to worry about there's anti-bribery statutes in other countries that can affect their conduct. And so there's still all the incentives and reasons for companies to make sure they have adequate controls to try to prevent those types of violations. And we've seen a lot of statements by various state attorneys general that they are going to, be at the forefront in this space. So while SEC may place a pause on it or extinguish it altogether, obviously they're a huge regulator and enforcer of FCPA, but they're not the only one.
So it's not going to mean a lot more business for America, or maybe we'll see. We'll see if it does or doesn't. So Justin, what about you on
Couldn't agree more with the TBD. I mean, I think there are a couple things that probably most people in this room would agree. The SEC is going to devote fewer resources to it, so there'll be less monitoring of it. I would say maybe boring, run-of-the-mill violations are not likely to be pursued. The challenge there is what actually constitutes boring or run-of-the-mill, right? The question is going to be, going forward, what does get the attention of a regulator, whether the SEC or someone else? If I'm advising a client right now, I am certainly not suggesting that there's a green light here. I'm suggesting that this is a window of opportunity to try and improve things, to try and identify any issues, remediate it, and resolve it.
And are you advising them to be boring?
Boring is always good in relation to a regulator.
Good.
Yeah. Hey, I'm an accountant. I specialize in boring. So
yeah. So keep
ask my wife and kids about that.
Keep it boring so you don't attract attention.
Right.
All right. Now let's turn to the internal reorganization at the SEC, and we're gonna have to go back to you. We're gonna just have to do it. All right. So first of all, I've read all kinds of things about the different offices. Which ones are open, which ones are closing, leases and all that, and also return to office. So everyone's back except at certain offices, or how's that work?
So everyone is back in the office now. I can't really comment on the leasing issues, but what I can say is that the regional offices remain and will remain an important part of the SEC structure. So I don't think you can expect to see the regional offices going away.
And with the change in your job, I mean, are you like on the road constantly visiting all these offices? I mean, what's the office for you? Return to office means what for you?
So I'm in Los Angeles most of the time, but I do, as I mentioned, San Francisco, Fort Worth, and Denver. So I will be, visiting those offices from time to time as well, and will be the supervisor for the enforcement program there. And
changing the structure so that there are the three. There's Northeast, Southeast, and West, right?
Northeast, Southeast, and West. So the Northeast is New York, Philadelphia, Boston, and Chicago. And not sure exactly that one fits in the naming. Right. Then the Southeast is the home office, Miami, and Atlanta. And then I think Sarah mentioned Jason Burt is overseeing the specialized units as the deputy for those.
So in terms of the mission and the day-to-day work, how does that reorganization affect things?
Well, so I think many of you may have been familiar with the previous structure before with the regional director. So in each office, the regional director oversaw both the exams and the enforcement program. That was somewhat decentralized. So I think part of the goal with this realignment was to have enforcement report up to enforcement and exams report up to exams, and to not have the regional director sort of in that role that was in between. So now, the enforcement programs in the West, those core cases report up to me in each region, and then the unit heads report up through the specialized unit deputy director.
Do you anticipate any kind of substantive effect of all this? Because we heard in some other panels, well, now there'll be more uniformity. You won't have the different offices. And maybe that's a good thing, maybe it's a bad thing, depending on what the office was.
I do think you're going to see more uniformity. I mean, I think I've already, being in the role for a very short period of time, I've already kind of seen more that things are different in different offices. So I think you're going to see things be a little bit more streamlined and more more uniform across offices. I also think having 4 of us is kind of nice because it is this blend of also being more open than maybe, more accessible than the deputy would have been traditionally, now that there's 4 of us. So I think it's a nice blend.
And are the 4 of you like a separate unit that's coordinating to try to get even more uniformity, or is the West still going to be the best?
The West is always the best.
Okay.
But we do talk, and I think the goal is to have a national enforcement program.
All right. Now let's talk about some of the process changes. And we heard about some of this on previous panels. So formal order authority. And Michele, we're going to turn to you to start us off here. So that's bounced around over the years. It was at the regional director, then it was at the enforcement director, then it was at the commission, then it was back and forth and back and forth. And now it's back at the commission level, right?
Yes.
So what effect, do you see any effect on how cases are brought, how they're investigated, or how defense counsel reacts to that?
Okay, so first, just let's have a little historical perspective. So before it got delegated to the regional directors, the associate directors, actually to the division director, and then it was subdelegated out, the commission had to authorize a formal order. And there was a process, just like the action memo process generally. It went through the comments by the division. It had to get calendared. The commission would preside over it. And when there was probably more of a sea change of reorganization of the enforcement division in the wake of Madoff, a determination was made in trying to make the division more efficient to delegate the formal order authority, and the reason for that is the group that was reviewing it determined that something like 99.9% of formal order requests were approved. And so it's time consuming to go through that process, it's resource intensive, et cetera. So the idea was to be more nimble, to have more immediate approval, and you're delegating it to senior people to make that determination. And then some of the subdelegation was taken away, where then it went to the enforcement director. So what I see are a couple things. One, it does cause a little bit of delay, but there always was a mechanism if you needed to get the formal order immediately, you could. But what it does do, for better or worse, the divisions have an early look at what a potential violation might be given a limited set of facts, and probably more significantly, it does give the commission an opportunity to opine if they come to a determination that they don't think this is a good use of enforcement staff resources. However, I will say that over time, when there were formal orders that raised potential, new applications of existing rules or different types of factual scenarios, they would go to the commission to get approval. So there was that avenue to get the commission buy-in, but of course that would rely on the judgment of the senior folks in the enforcement division to raise that. And now that's been taken away again.
So if it was 99.9%, why, and we understand that, this current administration is interested in efficiency, why did they take that away?
Well, I don't know, but it would.
You can guess.
I can guess,
Okay.
and my guess is it's part of the effort to centralize as much as possible, and that's one way to do it.
Mm-hmm. So given what we've heard about not being creative, could a defense lawyer, and Alex, you could chime in here if you like, or Michele, or Justin, could say, look, this is voluntary, but, this is just kind of crazy. This is a little too creative. So you're going to have to go to the commission. If you think, in other words, that the commission, this commission, won't authorize it as a way of kind of getting to that more quickly and trying to force the staff to do that?
Well, I would not recommend that.
Okay.
The staff will get the message about what the priorities are. So I really find it hard to believe that they're going to, pursue that formal order authority if there's some major issue where they're going to encounter a huge problem. And that isn't really how you want to start off your relationship with the staff.
Alex or Justin, any comments on that? You're
No,
going
I
to disagree?
agree.
You're going to agree?
Yeah,
All right.
100%.
All right. Well, it's worth a shot.
It was worth a shot.
All right. And so, Kate, have you, now that this has changed, have you seen any effect on terms of efficiency or what is being brought or not?
So, it's still early days, and it's a little bit more process than we've been used to in the recent past, but, so far I'm not seeing it hindering our ability to do things quickly.
All right. Another change, we heard a little bit about this before as well, is on the Wells process. And we heard about, open jacket, but I think there have been other changes in the Wells process as well.
So, yeah, I think a couple of changes, so most recently, the director or a deputy director would really only participate and take a Wells meeting if the enforcement action presented novel legal or factual questions or raised significant programmatic issues. I think you can expect a reversion to a position where if you ask, I think you're going to get a meeting with either the deputy or the deputy and the director.
That means
me
you.
for
We get to meet with you.
yes, for certain cases in the area, assuming there's no countervailing law enforcement issue. I would say this doesn't mean that you're going to get multiple meetings. I think at other junctures in the investigation, if you want to have a meeting with the senior leadership, that doesn't necessarily you're going to get every meeting that you request, but I think at the Wells process stage, you will get a meeting. And I would just make a pitch that, if you raise issues with the staff, that is raised with us, and that we do in the senior leadership weigh in on that. So when you raise an issue with the staff, just know that we are weighing in on that. So just because you're not getting a meeting on an issue doesn't mean we haven't thought about it.
So on a practical level, is it first a meeting with the staff, and then you could say, okay, we had that meeting, now we want another meeting? Or is it just you go right to the...
I would encourage one meeting. I would say if you want a meeting with the director or the deputy director, make that ask.
So at the Wells stage, you could say, you know what, let's not have a meeting with staff, we want to talk to you.
And you're probably going to get it.
And will you look at that as, why are they bothering me? Why can't they talk to the staff? Or is it like, no, this is fine and it's okay?
Well, I think we want to, if they want to have things heard by the division leadership, I think that's the goal. I think we've talked about this with the open jacket policy as well. I think a lot of that was happening in many offices before. But, I think the current leadership is going to be more supportive of an open and transparent Wells process. I think we want to hear from defense counsel. We want them to have as much evidence as we can provide. And I think we want to have a fulsome conversation with a defense counsel who can advocate for their clients and make sure that their positions are heard, and that, I think we all benefit from having defense counsel fully informed and having an engaged discussion.
Alex, what's your perspective on this change? And how would you say, this one I want to go directly and talk to Kate, or this one I don't, or how would you do it?
Well, first of all, I think it's encouraging to hear the Commission's stance on these revisions to the Wells process. We've heard similar things from, I think, Deputy Director Antonia Apps recently as well. But as defense attorneys, all we can do is read tea leaves as to how the Commission will treat the Wells process once there's a change in leadership. And we have been trying to read tea leaves, even when those tea leaves take the form of a 17-year-old law review article by now Chairman Paul Watkins. But I think what we all expect is a little bit more of an open conversation, a little bit more of a seat at the table. And that's encouraging, because Chairman Atkins has always valued predictability and transparency, and I think that's what we're all hoping that we'll get here in the Wells process, not just the written submission, but also a meeting when requested. To answer your question, Jordan, I always find it more constructive to meet with the staff first before going straight to someone at Kate's level. Of course, it depends on the circumstances, but I always find that's more productive and constructive.
Okay, and Michele or Justin, you have a point of view on this? Any different? No? Okay. All right, so penalties against individuals rather than companies. So this is another one where defense lawyers have been saying for years, look, the company was a victim, you're hurting their shareholders, the shareholders didn't do anything wrong, why don't you go after the wrongdoers? It sounds like, at least directionally, that's where the SEC is headed?
I think that's right. I think you're going to see more of a focus on individual accountability. And I think if you're going to have corporate penalties, there's going to be more of a focus on, looking at the 2006 penalty statement on that and those factors. So
one thing that I've always wondered about is, you go after a company, the company figures out a way to, do we really want to be in a fight with our regulator? We'll figure out how to pay them something and we'll be done with it. Individual has a little more on the line, like a reputation and a career and so forth. And so, Justin, I don't know if you can comment on how this may affect the way these cases play out. Is the SEC, which I understand is sort of down in total numbers, going to be able to handle it if you have a lot more individuals who may say, I'm not just settling this thing, I'm going to take this all the way?
That's exactly right. I mean, the direction here is pretty clear, right? For me, what I hear, if I'm involved in an investigation, I'm helping out, what I hear is that there is greater importance or significance to be able to contextualize the facts at play, right? And so typically what I want to be able to do, if I'm helping out with the matter, in order to provide proper context, is I want to be able to articulate, was there any material benefit or impact to the company? And as a lot of us know, materiality can get triggered a lot of different ways. You want to look at, obviously, the impact of the financial statements. You want to look at investor decks, meet or beat analyses, and make sure that there's not something lurking there that you weren't aware of. And then you're right. Then the question is, how does this impact individuals? Because a lot of times the work we're doing is with the individuals as well. And it's not awesome for individuals necessarily if the focus is shifted away from the corporation to the individuals. And so a lot of times there, I want to get in and look at the internal control environment, right? Did this squeak through because there was a failure to design, implement, or operate good controls at a company? Did the company evolve or grow into something and this kind of shook out? Or did you have a group of an individual or a group of individuals who intentionally circumvented that? And what I find is that if you can compellingly, incredibly answer those questions to the staff, this is going to be an increased opportunity and a time where there's an increased opportunity to influence where this outcome is going to go. And it's going to be, like you said, highly impactful to individuals as well as to corporations.
So from a company's point of view, it might be this is a good thing, but from the individuals, Michele, you wanted to comment on this?
So I do just have a general observation, which is this: we're going to focus on individual accountability. And what I see as, I'm a little suspect of that in the sense as if that's something novel, right? I mean, the entire 29 years I was at the SEC, no one ever takes a deposition, a testimony of a company. You're speaking to individuals outside the 30B6 context, which of course then that's an individual too. And so there was always a focus on talking to the potential participants in the misconduct and understanding their role in that misconduct. And oftentimes, there are situations where it's very difficult to find the individual, especially in the corporate context, who was solely or only responsible. And so that is what gave rise to a lot of the cases in the wake of the financial crisis where they were corporate negligence cases, or there was only charging the company with fraud because maybe the one individual whose fraud you could impute to the company was a lower level person in the scheme of the organization of the company that in the exercise of appropriate good use of prosecutorial discretion determined that was somehow unfair. So to me, the bigger question is what will happen, and this I think is positive for companies, where you're in that corporate negligence world and there is no CEO, CFO person that can be held accountable. Will the commission not bring a case?
So you see it as positive for companies, but same as it ever was for individuals?
I think so. And I guess it depends.
Which is net positive then, from the defense side?
Yes, yeah. I think so for...
Okay. But we'll
in that
have,
way.
we'll,
But TBD.
we'll have to see. All right, Kate, I'm going to let you off the hook on the next question for sure, which is I want to ask about the overall mood at the SEC. And based on what people have heard, you know, a lot of this might be sort of rumor and so forth. I'm going to go down the row here. We'll actually start with Michele, and then go to Alex and Justin. And you got to be careful. Got to be careful here. You know, don't reveal sources. But you know, we've heard all kinds of stories. You know, people being, chief trial counsel being shifted to doing, looking at fax machines and all kinds of things, right? So, what have you heard about the mood and what's going on? And on top of that, as a defense lawyer, does that figure into any of your approach to any matter?
So as to the latter question, that's easier. I think the answer is no, it has not affected that in any way. As to your other question, I think what I'm comfortable saying is it's a very challenging time for the staff.
Alex?
Yeah, I mean, it's a difficult question to answer, and certainly don't want to betray confidences. I think that what the general consensus I've heard, as Michele said, is that it's a challenging time. There's a lot of uncertainty. They're finding out about changes in priorities in real time, like we all are. And so, you know, it's difficult to know where people stand and where their cases stand. And I think that's always hard. And so, you know, has that led to an increase in the number of resumes we're receiving? Of course. But I think I've also talked to friends of mine at the government who feel totally supported and feel that their work is going to continue and that they'll continue to do very meaningful enforcement work going forward.
Justin?
So the one thing that I think you have to acknowledge about this staff is when you're on staff, the resilience of the staff is always quite remarkable. Having said that, they have taken a hit, right? And so, I mean, I only left 2.5 years ago, right? I have a lot of friends at the commission in a lot of different regional offices, so you can't pinpoint anything. I would say stressed and distracted, right?
Just like the rest of us.
Right, I'd go with that. I will say though, there's a pretty remarkable shift since Watkins has come in. That there is, I would say, kind of a first sign of hope that while there still might be some change coming down the pike at them, that there is his leadership has ignited maybe a remarkable sense of hope amongst them, that it'll be a little more stable going forward, whatever comes.
I'm going to stay with the defense lawyers here, defense side. In light of things that people have been hearing about the SEC, what about your clients? Have clients said, you know, that internal investigation that you think we really need to run, do we really have to spend that much? You know, it's not going to get us in trouble. And, you know, this bribery thing, I don't think there's anything there. Why do we need to, you know, at the margin, is it harder now to convince clients to take that extra step, to be concerned about a compliance issue? And if so, how do you deal with that? We'll start with you, Alex.
Short answer, yes, that conversation comes up far more frequently than it ever did before. I think generally speaking, it's more of a question posed out of curiosity rather than one where they're determined that no, we don't need to spend this amount of money for an internal investigation. So I think clients are still realistic about the work that needs to be done, but it's definitely a topic of conversation where it wasn't before.
And in your conversations, do you say things like, and you know, I heard someone said this earlier today, that administrations are short, statutes of limitations are long. I thought that was a great line.
That is a good line. I was less articulate in responding to a client with a question about the FCPA recently, but yes, that's the general sense.
Michele, what about you?
Yeah, similar. And what I would also say is, while obviously the SEC is extremely important to a lot of companies, in particular the registrants. However, there are other constituents and stakeholders that they have to answer to: shareholders, clients, state regulators. So the fact that there's other reasons, as well as good corporate firm governance, to have, proper procedures and try to avoid running into any type of regulatory or, problematic conduct. I mean, those remain. So like Alex said, it's more the curiosity. Well, do you think if this went, would this get referred to enforcement if it's an exam? More that type of thing, as opposed to, whoa, like, why do we need to do this now if the SEC isn't going to come knocking?
And Justin, you get the last 22 seconds.
Ditto what was said. I'll add 20 seconds to that. Most of our clients are motivated by frankly getting things right. How it's going to be resolved
good
with
clients,
right? Good clients, good counsel. How it's going to be resolved is a significant matter, right? And now how the SEC is going to resolve some of these might be changing, but fundamentally, companies, counsel, audit committees want to get it right.
Okay, well, thank you to the panel and especially to Kate.